All right, I call to order the Subcommittee on Family Court of the House Committee on Children and Family Law. It is October 27th. Just to review, last week I handed out another copy of the subcommittee assignments. Do either of you need another copy of that? Yeah.
Thank you.
We also last week looked at the report by Representatives Gregg and Raymond entitled Improving New Hampshire Family Court Pretrial and Mediation Practices, Pretrial, Alternative Dispute Resolution, Mediation Training and Supervision. Do any of you, either of you, need copies of that, which was handed out last week? You know, if we add the 2 weeks together, we'll have a quorum. It is amazing the number of life intervenes that have hit this subcommittee. Surgeries, various other things, family emergencies, and so on. Life intervenes sometimes. Last week, we also looked at a wonderful report, not that the other wasn't, from Representative Nelson and Raymond, which is a list of what states have what kind of family courts. Now, I bet you have one of these since you authored it, but the Honorable Counsel may not. This breaks out which state has a completely separate, dedicated family court, which state has a subdivision of a particular court, which states have family court issues done in general without any breakout, whatever. It's a very, very helpful report. If I could have the rest of them back. This is very, very helpful. It also has some forms in here that we were asking about, so thank you very much for that. So that's last week, and eventually everybody will have copies of these. Now, presented today, and neither one is here to present it, is the current intersection of domestic violence and family courts in New Hampshire, Representatives Gregg and Rice. This is very important because, as we had said many times in the special committee for 2 years and in this subcommittee for this year, that sometimes there's a domestic violence charge in Superior Court while custody issues are being discussed in family court, and neither court knows the other court. And we were told that's a very difficult thing to do, to which I say, then solve the problem. Because there are numbers of ways it can be solved. So let me pass that one around.
Thank you.
And take a minute to read it, please, if you would be so kind as to. Because it may be something indeed that we wish to address. Hmm. Could you put your mics on, because this is being recorded? Thank you.
Yes, Mr. Chairman, thank you.
Yes.
RSA 490D does give family courts an original jurisdiction in 173B matters.
Okay, we're going to need to have those numbers again, and you were saying RS,
Yeah, I'll give you the exact site for it.
Thank
just
you.
a second. Okay, it's RSA 490D2, D
what's
says
the letter V as in Victor?
D like on David.
David, okay?
Okay, it gives them original jurisdiction in actions under 169B, C, D, and also actions under 173B. Okay.
Give me the letters with military code. 169 what?
Okay, well, those are child abuse statutes.
169 all the
Yeah.
way through, okay?
Yeah, okay, 169, and then actions under RSA 173B relating to the
D,
B like in
B,
boy.
173B.
3B. Yeah, that's the domestic violence statute, sir. Relating to the protection of persons from domestic violence, except for concurrent jurisdiction with the district court to enter temporary orders under 173B4. Okay, so they basically have district court and circuit court have jurisdiction on that. Okay, both have concurrent jurisdiction on it.
So family court could hear this.
Oh, yeah. Oh, yeah, particularly since, absolutely. And when you look at the scope of persons protected, family courts can do it. Typically, in my experience, the 173B courts are, when you're in district court, is typically related to criminal charges. Okay, so what you end up seeing is bail protective orders. Okay, and you can get civil orders under district court, but that's a different matter. But so in other words, if you have that, and it's usually, it's usually intimate partner violence, somebody's living with somebody, or husband and wife, father and parent and child, these kinds of things. So they can hear that.
So then, if that be the case, what would we find to be the problem?
Well, I think the problems that were laid out are somewhat different. For example, I'm thinking about that horrific case up in Berlin with Marisol Fuentes and Mr. Gleason. And there, the courts simply weren't communicating enough in terms of information, and that kind of communication needs to be enhanced. When I read by way of further answer, when I read the report on that case, they were talking about expanded use of lethality assessments, which, if you're familiar with them, lethality assessment questionnaires, and to be able, so police can be able to take, or law enforcement can be able to take further action and further protect victims of domestic violence or abuse. That's kind of where it is. I think courts at the district court level, DV 173B actions are typically confidential, all right? And that may be a little bit of a problem. So in other words, non-parties can't get that information. Law enforcement might be able to under certain circumstances, but in other words, you can't pick up the phone and call the court call center office and get anything on a DV if you're a stranger to that action.
So given what is recommended in this document, what would you highlight as being very helpful and practical and needed?
All right. Well, the unified database, I think, certainly makes sense. We've already discussed the confidentiality rules. Criminal cases are not confidential in the strictest sense of the term. If I need to find out if somebody has a criminal record, all I really need to do is call the call center, and if I have a date of birth, I'll get all the case summaries I need on somebody who has a criminal record. So that I wouldn't see as a bar. Then if I'm on the portal or something like that, then you can get the pleadings and things like that. So in other words, getting the criminal matters wouldn't be the problem. So I think what you end up with is that you need a criminal violation of the DVP order. And then that goes into the system as a violation because that's a criminal offense.
Jody?
Thank you, Mr. Chairman. Yes, I agree that a shared database would be great. I don't foresee that happening in the near future. And two ideas that I had was just to, number one, as we've been talking about educating people, because people in family court are heavily pro se. When we have that person initially coming to family court, and they have that person who's supposed to kind of guide them a little bit and give them the appropriate information and forms and so forth. I think maybe just educating the person that if there is a protective order or there are criminal charges, that they must bring that up at their hearing, because probably people would just assume that a judge would know that. I think that would be helpful. And also too, and I think that this had come up in one of our hearings, and I believe it was Attorney Cregan and one of her associates was talking about the possibility of just clerks checking every day, and that might be just a part of their procedure for the day in reviewing the dockets. So those are my two ideas.
Yeah, they could do that. Just by way of helping pro se litigants generally, one program that I was a part of many, many years ago, and that Massachusetts has, that we might want to look at, which is the Lawyer for the Day program that most of the counties in Massachusetts have. And what that is you will find lawyers who will volunteer their time. And if you have the space in the courthouse, you can do this, where they will come in and meet with indigent self-represented parties, or people who meet roughly the income qualified programs, and they usually help them fill out pleadings. They give them legal advice as to how to proceed with their case, things of that nature. And that would probably be helpful, certainly in the family court context. As a matter of law, well, let's put it this way. Family division clerks and office staff are not supposed to be giving legal advice to self-represented parties. As a practical matter, they often do, and they shouldn't be doing that.
Can I?
Please.
So they do have like a person who gives an orientation, right? Would that be the right term?
Well, are you
Right.
talking about like on a first appearance?
When I go to the courts and I don't know what I need to do
Oh, okay.
in terms of divorce, it's my understanding that we've been told that there are people who say, okay, these are the steps. Here's the paperwork that you need to fill out.
Oh, okay.
Yeah, that's what I was talking about.
Oh, okay. I think you're talking about first appearance. First appearance is optional for attorneys to appear, but it's required as a general proposition for self-represented parties. And sometimes it's done by Zoom, where they have to certify, or via web, where they have to link in and watch what the presentation is. Or they either have to attend in court, attend in court. And typically, where it's done in court, they bring everybody together, and usually a judicial officer will come out and explain the processes to them, and they will explain what the processes are, what the events generally are, how your case is managed for you. So it's going to be something along the line of temporary orders, structuring conference, pretrial hearings, whatever. And then what they do is they talk about mediation and encourage people to mediate. And frequently we'll ask them for a financial affidavit and refer it to mediation to see if the parties want to mediate. They don't have to, obviously. There are certain let me rephrase. There are certain circumstances under which they have to, but can seek exceptions of the court, and there are certain circumstances where they don't, according to court rules. I think you might want to look at, to get a further handle on that, you may want to take a look at Family Division Rule 2.13 in terms of mediation, what family divisions require. And that's typically how it happens. But these people aren't supposed to be unless it's and I can't see a judge or a former marital master or a referee, retired judge or even a referee, giving legal advice to a self-represented party.
I don't, that's what I wasn't at
Yeah.
all inferring that.
Yeah.
Just,
I didn't think you were.
oh, okay.
Yeah, yeah. Because typically when that happens, you typically see a self-represented party handing something to a clerk, and they look at it and say, "Well, that's not going to fly. You need to redo this." And that is not the prerogative of a clerk in the clerk's office to do that. Judges hear about it, and they just typically, they just kind of say, "Well, he or she is not supposed to do that," but then nothing happens.
Page two of the current document has under sub D, consider a family safety docket. What room is this, by the way?
231.
231? Okay, I think I may have a wayward, not wayward, but a late arriving because of other more important things here. 231, okay. We noted in a previous document that some states actually have a separate family court, not a separate family division, but a court. And that's a possibility.
Sure.
You know, he'd been talking, I have read with this special committee that met the last 2 years, was like the fourth or fifth special committee in a series of them going back to the founding of family court. And every one of them talked about one case, one judge. Every one of them had recommendations that we were told last year probably can't happen. But we were also suggested that while working collaboratively is still a very good idea, just simply saying, so we're all agreed and march on to the next thing is probably not. And that if we both agree that it's a good idea, let's get it in statute and let's get some teeth into it. And I am increasingly convinced that would be helpful.
Yeah.
We're done for the year in terms of filing new bills, but we've got a whole year to work on all of this paper and look at examples. And I do hope that this subcommittee will go back into business after the first of the year. There seems to be reason to believe this is possible.
Sure.
So just some thoughts. Anything else on this?
Okay, it's an interesting idea. I think a family safety docket. That's an interesting idea. I'd have to study it somewhat. Having had my share of high conflict cases in the past, as I'm sure you're aware, we already have the complex case docket where the issues, when they get really murky, are assigned to a special court. Typically, cases do stay with one judge right now. It's certainly preferable, and they typically do, unless a judge has to be excused for some reason.
Say a little bit more about complex case docket, if you would, please.
Sure. Complex case docket, well, that's a mouthful. The complex case docket, last I knew, was in Brentwood. I don't see too many of the cases of there anymore, and I had some a few years ago. They were assigned to a special judge, and I'm not even sure if it's still functioning anymore, but when it was, if there were very complicated cases of custody, finances, or things like that, and the parties agreed, it would have been assigned to the complex docket. It used to be held in Brentwood and in the southern part of the state, and at that time it was Judge Lemire who was in charge of it, and they would be over in Rockingham County Courthouse in Exeter. I mean, not Exeter.
Brentwood.
Brentwood, sorry. And typically that's the way it was. I haven't seen any of those cases in a long time and haven't needed them. But high conflict, I just my initial thoughts are that our court system already deals with high conflict cases. I don't know that it hurts anything, but I don't know that it helps anything either.
Obviously, or I think, one of the litigants could bring before the judge in family court, oh, by the way, my ex is in Superior Court on a DV charge.
Sure.
But I wonder how many people in this, I'm representing myself, I'm scared to death, I don't feel good, everything's collapsing, would think of everything.
Yeah, yeah, that's certainly possible. One thing you might want to look at is whether courts independently find other cases, and typically they can. So if you go into the Odyssey system or whatever it was, you usually find companion cases. You know, like I said, they might not find the DV case, but like I said, criminal cases are a matter of public record. The only thing that might be sealed in a criminal case might be for the protection of a victim or something like that. Like a name or address might be withheld. But if you go to the court call center, it's basically and you can ask pretty much about any case and just give us a name and a date of birth, and if they have a case summary there, it'll pop. With the exception of a DVP, that isn't going to go out. The other thing that might not go out would be a guardianship case, which are confidential, and other types of cases that are confidential to the parties. Confidential as a matter of law, adoptions, guardianships, things like that. Certain types of abuse and neglect cases under 169, you won't get those. But if you're talking about something like a divorce, you'll find that. If you're talking about something like a criminal charge of virtually any nature, you'll find that. Those are public record.
And if the person who was the alleged victim of the DV is the other spouse or ex-spouse, that person could waive the confidentiality by saying it's about me. I don't mind if you.
No, I don't think so. I
No?
think they're confidential as a matter of law. I don't think you get to apply. I don't think an individual party gets to waive statute in that respect. Yeah, yeah. I mean, now that said, there's probably little to prevent a party from broadcasting their pleadings or something like that. I don't know what the sanctions would be necessarily, but that certainly would be something they could do. I certainly wouldn't advise doing it, but something that does happen.
Okie dokie. Well, you know, there is a penalty to being popular.
Well, let me know when you find somebody popular, but the penalty was,
She just walked in.
yeah, right.
Okay, we have been just talking about this. And you've got one to hand us, okay? We will hand this. We
It's
will
pretty
blah,
short
blah.
and sweet, but
Okay. Okay, we're just about ready to go on to the next one.
go,
I need two.
go.
Okay, thank you.
You
Alright.
could bring 6, but
I will need one for the handout.
yes,
So if you have
here
one,
you go.
thank you. Everybody else now I know is not coming. Representative Rice says she's away. We had heard she was
Okay.
going to be here, but she's away, so that means she's not here. Just for the sake of repetition, we're mentioning the fact that it is possible for this subcommittee to go back to work next year.
Yeah.
And which means all this nice paperwork that everybody's going to have, we've got a couple of months to chew on it and make recommendations. We also looked at the question of our former liaison got her appointment on August 11th and started in her new Fed job on August 13th. And Judge Ellen Christo and I periodically converse, and she has told me that they are looking for somebody to fill, among other things, that liaison to this subcommittee. And as you can see, we have no one from judiciary here today. Maybe we will. But let's just say that back when we were flowing at a bit more full tilt, while it is good to be collaborative, it's not a bad idea to have things in statute. And it could well be that with numbers of these things that the special committee believes are being implemented, and numbers of things we may recommend in a year's time, when it's time to file bills again, we might put them in as bills. I do not know if some of the recommendations of the previous 3 subcommittees over the decades were ever put into bill form. That's a research project that's going to be worked on. But the fact that they kept coming up again and again say to me that probably not.
I agree with you, it probably hasn't, but I don't want us to forget the fact that we can review the bills that come before us this year and add some of that verbiage as an amendment to the bills rather than wait too long to get these things done. I just quickly glanced at this and in this the current intersection of domestic violence in family court and how the cases appear and so forth and so on. We have the legislature has passed a bill that would create a situation where criminals who have certain protective orders or have committed certain crimes, their information is going to be transferred from one court's jurisdiction to another so that the judges are aware of their criminal behavior. Well, I think when it comes to a DV order, we can have some sort of legislation that will require the criminal court to report to the family court of a particular situation where the person has been found guilty of the crime of domestic violence, and therefore help the family court be aware that that's what's going on, because those judges just are not aware.
See, that's why you get the big bucks. I never thought of that, but we will be having some bills come before your committee next year, or our committee next year.
Well, quite frankly, Representative Markell and I have been involved in a case in another state and jurisdiction that we've seen this specifically happen. However, last week, that particular judge was made aware of some issues with that particular person and has ruled accordingly as of Monday. So making judges aware of the full extent of a particular case, I think, is extremely important, especially when it comes to domestic violence.
One thing, if I may add, typically in Massachusetts, since I practice in both states, one thing Massachusetts does that perhaps New Hampshire should be doing is that if you have a family court case, in Massachusetts, it's probate and family court. Okay, the judge gets a copy of a criminal record from either or both parties, and it's usually presented to the judge in a sealed envelope with the case file. And when the judge opens it, they find out there's a companion case going on. Okay, and so they can rule accordingly. And what it is that we have a, criminal records history and so forth, and which is comparable. Massachusetts, they call it a CORI. Okay, it's it's offender records is what it is. And what it does is that it lists the violation, the statute, the nature of the charges, and whatever disposition there was, if any, at the time.
So I think it's important for us
Well,
to,
we're being recorded, so would you turn your,
thank you.
thank you.
I think it's important to keep that in mind when we're looking at our legislation this year. I don't know how many bills are going to come before us. At this point, I'm being told that it's not a significant figure. However, there are over 1,400, almost 1,500 bills that have been filed. Again, I don't know how many are ours. I won't know that for a little bit.
Have you gone down the list? Because the list of bills numerically is available on the website. Have you gone through them to see the titles?
I have,
Yeah.
and some of them can be sent to CJ, DHHS, or us. Judiciary, things of that sort. So thank you, Jody. So I'm not really sure. I don't see us having a lot, so we will get through our early bills as quickly as possible so that we can look at the other bills and see what amendments we can put on there to answer to the family court issues. And I really like to work hard to get that done, rather than wait until September to introduce new legislation.
Agreed.
Sure.
All right, can we go on to Chairman DeSimone's handout here about counseling and therapy?
So again, the research that I did, if I may speak on that,
Please.
the research that I did was, the research is pretty vague because many jurisdictions throughout this country, they really don't, the courts don't get the information as to whom it is that is seeking counseling and therapy. However, what they do say in the court in jurisdictions is that the family court is all about navigating very complex issues. And again, I'll refer to the case that Representative Markell and I are involved in. There are usually significant mental health issues involved when mediation doesn't work. So the people who wanted to abolish the family court felt that mediation was the way to go. Well, that's all well and good when you have two parties who are willing to mediate and get through that. The majority, unfortunately, by the time you get to mediation, the majority of the people that we hear from have already decided how much they despise the other person, and they're not willing to work together. Again, in the particular case that I'm in, one of the people has claimed that they are in therapy. However, the doctor's name that they put forth to the judge happens to be an OBGYN, and the person who reported that happens to be a man. So I don't know why he's going to an OBGYN, but he is. So the other party, the female and the children of the couple, are in therapy, and they're making significant strides. So the court can hear that you're making significant strides in counseling and therapy and whatever that may be, and ask you to go back to mediation when you're a little bit healthier, rather than fight it out in court, rather than it costing the litigants copious amounts of money. So that's another reason why family court, I believe, should not be abolished, because these judges are used to hearing these cases, and they're used to saying, you know what, why don't you two give mediation another try? So pretty much, that's what my research showed, and there's a very vague synopsis of it in the paper I just gave you.
I do have one question,
Sure.
the third from the bottom line. It's require families to work together. I'm not sure the judge has that authority, is to require it. The judge could strongly recommend it, give advantages why it would work, drop a few hints. But counsel, is that true that the judge can require it?
No. What they can do is that, with all due respect,
Yep.
courts can order, courts can actually say, they can suggest it. In other words, they can say, well, actually, in a parenting plan, they can order it to a certain extent.
That's what I was
Yeah,
talking
so in
about.
other words, courts can order, when you look at a parenting plan, that parties shall, okay, and it's do the following things, okay, and that's in the best interest of the children or whatever. So courts do have that kind of authority.
And that's where I was going with that.
Yeah, so they
word
do have that
required.
kind of authority. On the other hand, if you're talking about mediation, there's already two sets of court rules, actually three if you include Superior Court. The one that I'm thinking of is how it works in the family division. The mediation rules are a little different than they are other places. So, for example, if you want to take a look, I'll briefly summarize what the Family Division Rule 2.13 is. In divorce actions and legal separation actions in which there are minor children and parenting petition cases, parties shall be ordered to participate in mediation unless the court finds that mediation would not be appropriate due to the factors listed under RSA 461A7. And participation may be ordered in new divorce or legal separation cases without minor children. Now, if there's a finding of domestic violence as defined in RSA 173B1, and if the parties agree to mediate, all mediations shall occur at the courthouse or over video conferencing unless the court determines otherwise. So that may be something you may want to think about. Courts are going to be involved in scheduling. Attorneys may attend mediation. Mediation will only be ordered with certified mediators pursuant to RSA 328C. And also, you can substitute private mediation for that requirement. So basically, this gives the parties some flexibility. If they don't think mediation is going to be productive, you can contest it. And remember this, mediation has to be a two-way street.
Right.
If one party is not going to settle, mediation is going to be a waste of time. And, one of the things that typically comes out by way of further answer on the mediation topic is that frequently in the initial part of a case, one party might refuse to mediate because they're really aggressive in terms of going after the other side. They want their day in court. They want this. They want that. She is going to pay for the wrongs they've committed against me, and so on and so forth. And then as the case goes on and they watch, and if they're represented, and they watch the fees escalate, because then all of a sudden, and as they settle down a little bit emotionally, mediation at that point can become an option. But to really have a good mediation, you really need both parties willing to compromise a little bit. You also need adequate discovery, because if you don't have adequate discovery, mediation is a waste of time. One of the things that comes out of that is mediation appropriately timely. If we haven't completed our Rule 125A and haven't gotten at least our mandatory financial self-disclosure, why would you even go to mediation unless both parties wanted to settle the case and both parties knew what the approximate size of the estates are and didn't have any problems with it? But that's usually not the case. The other thing, by way of further on mediation, at least ADR in the broadest sense, alternative dispute resolution, and please stop me if I'm talking too much, is that neutral case evaluation tends to settle cases. And that's a very different creature than standard mediation in this particular, in this instance. Neutral case eval is where you get an assignment and usually a retired judge or a retired marital master will sit the parties down, you typically in the courtroom that isn't being used at the time. Both parties will present their exhibits, present their case. It's almost a form of a mini trial. And then what the judge will do is say, okay, I've heard the case, and if you take it to trial, this is what the likely settlement is. So you can either take care of your case right now, or you can spend whatever amount of time you want and time and money to go to court and see if you can get anything better. And typically it settles cases when parties hear it that way.
Typically it does, but sometimes it doesn't.
Sometimes it doesn't. I mean, you get,
I agree, Representative. Typically it does, but sometimes it just doesn't. And
Yeah.
we all know that. And that's, again, why I go back to the fact that abolishing the family court is not going to answer the questions that our constituents have and the concerns that they have with family court. I think teaching is more the route to go.
yeah, I mean, that's a very good point, Representative DeSimone. And, if somebody has that in their head that this is what they want to do, they'll get their day in court and they'll get the result that they get.
But if the retired judge in neutral case evaluation says, oh, if we go forward, the judge will most likely find for you, then that one isn't going to be very happy and we'll plow on.
Well, yeah, I
Yes.
mean, if it's, and once in a while you get people like that, who are just so fixed and that they're going to try the case no matter what. I've had cases like that.
We had testimony of people that my assumption is like that.
Yeah, yeah, and if they get like that, then and if they're self-represented, it's one thing, but if you're paying an attorney, then, they told you what it's going to be. Frequently when I deal with my clients, I say, look, if you're this is how I think your case is going to go. Right now you're here in terms of attorney's fees. If you can agree to settle your case here, I'll give them what I think the result's going to be. If you accept that, fine. But if you want to run your bill up, well, that's up to you.
Okay. Representative, yes.
So I do know in the particular case I've been referring to that the couple was in mediation. The one of the parties frequently stated that that party was not under any circumstances going to share anything that he had financially. And so the mediators explained, just as Representative Markell said, that's not going to work. And then the person unfortunately went to court and complained that they were up to tens of thousands of dollars in legal fees and they weren't going to give the other party any money at all. It is specifically for the children or anything else, and The judge specifically stated, are you sure that's where you're going to stand? Because, sir, it will not bode well for you. So the judges try to help people come to an agreement. Look, let's do this. Let's do this. Let's do it. Some people just won't. And again, that's why sometimes we have to go to family court, and it's sad.
Yeah.
Which is one of the reasons why in the opening introduction to rules of evidence, it specifically says that the rules of evidence are guidance here and not mandatory,
Correct.
because you've got to be flexible. I should know the page number. I've read the book enough.
So also, this particular judge said to this person, this is the amount that the plaintiff is asking for child support, and how much are you willing to pay? The person said, I'm not willing to pay anything. And the judge said, why would you not want to support your children? Because I'm not giving her a penny of my money. So the judge said, and I quote, to the plaintiff's attorney, this figure looks a little low. And the attorney said, well, Your Honor, I went by the formula. And the judge said, well, the formula is the formula, but as a judge, I can increase it or decrease it. And the attorney said, absolutely, I understand that, Your Honor. End of story. In this particular case, the judge increased it.
Can the
So
judge,
it can happen in court.
can the judge compel a financial discovery for the
Absolutely.
purposes of?
Absolutely. And this is one of the more common things I run into in court, and people who want to play games with discovery, which is what it's called, when you exchange different types of information, legitimate requests for different types of information. And typically when I run into this, I try to resolve the matter informally. If the other side's represented by counsel, I try to resolve the matter informally. You know, you pick up the phone or send a letter and say, this is what we're missing. This is what your client needs to provide. We asked for this in discovery, or it was part of mandatory financial disclosure. Please comply, whatever. And if I don't get that, or if I get basically ridiculous objections in discovery I've already served, then what I do is I file a motion to compel, and with the court, and I have my standard motions to compel, and they're quite comprehensive, and they work, in my experience. And if you don't comply with a motion to compel, courts can do one of a couple of things. First, they can fine you in contempt, okay, and the second thing is that they can result in motions in limine, which will exclude certain types of evidence from coming in, or preclude an opposing party from introducing certain things. So, you know, and in extreme cases, you know, you could be jailed. And it's rare in New Hampshire that happens, but it's possible.
Are we finished with this? A little bit more, Ernie? I think so. Thank
Yeah,
you. This is a wonderful jumping off. And the last item we have is addressing pro se litigant challenges in New Hampshire. This came in recently, and it is filed by Representative Gregg, Representative Nelson, and me. And Representative Nelson, would you like to present this to us, please?
Thank you, Mr. Chairman. Sure. I think that we've gone over a lot of these, issues, challenges, complaints, and I think that we've all, heard from our constituents these same themes, and our suggestions are really just educating the pro se litigants on what the process is, what their rights are, what their resources can be. I just, in my experience and with constituents who have issues, I just think that the number one issue is communication and educating pro se litigants.
I don't remember when this is left over from. It may be from the special committee, but I had initial conversations with Sarah Blodgett from the Bar Association about what I am affectionately calling baby's first book of going to court. Because although it is correct that there are documents and videos, most people that I've talked with said, I don't know what to do, which means it may be a good start, but what else do we need? Now, I'm meeting Sarah Blodgett on another matter tomorrow, and I will just refer to the previous conversation and say, we will be, and thank you, and she says there's money available, which is words I love to hear, would like to go forward with that gracious offer on their part, and give some content to what could go in that.
Thank you, Mr. Chairman. I 100% agree. And I also, in my opinion, think that this book should be, and I'm not saying anybody who is going to family court is a dummy, but on the lines of Family Court for Dummies, right? Like, remember those for Dummies books that we had that simplifies things and gives bullet points. I think that people are also, when they are going through this process, they're very burdened with lack of time. And so watching a bunch of videos or trying to read complicated documents just doesn't really happen.
Representative DeSimone.
Thank you, Mr. Chair. One of the things that I have had discussions with the judicial branch is that asking about how we can educate the general public because there are so many pro se litigants. So there is some sort of a little brochure that is available. I'm in the process of getting a hold of one of them to see how comprehensive it is, but I really believe that if there is one, it needs to be worked on. And if, again, there is one, that when a person goes in to file for the divorce, that particular brochure should be handed to that person immediately. And the clerk needs to simply say something to the effect of, this brochure could be very useful to you considering that you are representing yourself. Please go over it with a fine-tooth comb, something to that effect.
That's what we hope to work on, yeah.
And there is some sort of a brochure. Representative Markell, I'm not sure if you've ever seen that.
Well, I might have seen something. I know Massachusetts in the past has had things like that, that they have handouts for self-represented parties. But that's what I recall. Usually when there's either a packet such as, typically in the family division where there's parenting cases, divorce cases or whatever, there's typically a little packet that goes out with it. It's usually dealing with mediation, usually dealing with mandatory self-disclosure, which is part and parcel of parenting and divorce cases where financial disclosure is relevant. Things like that.
Could I ask
Sure.
you to try to secure 8 copies of that, one for each of us and one for the file?
Sure, I think I have
And
those, yeah.
if you could get one for yourself and then one for the kitty and one for the rest of us, that'd be really
That's
good.
my plan.
Yeah,
Thank
okay,
you.
Okay.
Excuse me, Mr.
Yes,
Chairman.
yeah, go ahead.
I should have thought of this. I'll take a trip down to Derry, the courthouse
Oh,
in
right down to
Derry,
Derry.
and see what brochures or what
Okay.
info they have there available for folks, and I
Mhm.
will get back to you guys on that.
And if you can get 8 copies of it, that would be great.
Sure.
Okay.
If it's okay with the chairman, I will defer to Representative Nelson to accomplish that task then.
And typically
Happy to.
Yeah, typically these forms are available online. If you go to the Judicial Branch Web Center, Judicial Branch website, and then you click down on the family law, and then click down on family law forms, and they alphabetize them. They have a lot of these things online, okay, and they're served typically with, if you're talking parenting petitions and divorce with minor children, that usually comes in the packet that's sent out to you for service, so both parties get them.
I'm looking, that's helpful, but that may be step 2. I'm looking for a step 1 that is, again, baby's first guide or first guide for idiots or whatever
okay.
cute we want to say, that is the first thing you read. And then they refer to this packet, that website, the other thing. But
Oh,
some
I see
people
what you're
jump in
asking.
the
Okay.
middle and they're lost.
Yeah, okay. Yeah, I mean, I can understand that. I see where, just jumping ahead here, I can see perceived unfairness. One of the things here is that in New Hampshire, parties are presumed to have we don't defer to parties' lack of experience and lack of legal expertise. A good example of that would be read the case of Inree Birmingham from 2006. Supreme Court basically says self-represented parties are going to be held to the same standards that represented litigants are held to. Oddly enough, the federal bar, however, is a little more deferential to self-represented parties and doesn't quite hold them to the same standards. As to being unfair, if you don't know what the law is, and if you don't know the facts of your case, and if you don't know the law, and courts are supposed to be dealing with rule of law, and so if an attorney comes in and is up against a self-represented party, and an attorney who knows the case and knows the relevant law, yeah, you are at a disadvantage. Okay? This is what I do for a living. This is basically, and I'd like to think that I'm reasonably competent in it.
If those of you who were part of the special committee before will remember the 12 hours of testimony, and I think we kept hearing the same, it wasn't fair because that stupid judge did such and such. Those are questions that should be answered ahead of time. You will see when you go to court. In family court, the judge has significant discretionary power. And, well, I want the rules of evidence to be applied literally. Well, if you've read them, no, you don't.
No, you don't.
And one person even said to me, I want any offered, the word is proffered, but offered piece of evidence to be accepted by the judge. And my response to this person privately was, even if it has no probative value, which I had to explain, and is prejudicial because it talks about stupid things you did as a teenager, and the whole purpose of that is to make you look like a fool, do you now want anything either you or the other party offers to be accepted? Well, I guess not. I didn't understand that. I know you didn't. And so those are the things that would need to go into such a document. The judge is not necessarily corrupt.
Correct. I just looked it up on my phone while you were talking and I was listening to you.
You can do both.
There are 14, all I typed in was New Hampshire Guide to Pro Se Litigants in Divorce Cases.
Okay.
14 pop-ups
Okay.
that talk about exactly what Representative Markell and you were talking about. However, I think the problem is that, number one, some people are not computer savvy. Some people don't have computers. Some people get frightened and don't know what it is they're asking.
It's overwhelming.
Again, I think that it behooves us as a legislature to not necessarily hold their hand, but maybe to guide them by providing a brochure or a packet like Representative Markell spoke about when you go to court and file for your divorce. And that may help these people to not be able to come back and say, well, nobody ever told me.
One of the things is that people are presumed to know what the law is, because the reverse of that, is just creates havoc. The rules of court are posted online. They're conspicuous. They're written. Perhaps I'm looking at it from a different prism, but they're written in fairly clear language. There's not a whole lot of Latin involved or law French or anything else that would tend to confuse somebody. One of the things that's happened is that as the practice I see, we're getting away from confusing terms that might confuse, that are terms of art either in Latin or anything else. And you see things in the family division, pretty much in plain English terms. And one of the things that, and by the way, the opposite side of this is I've seen some very well researched self-represented parties who did very good jobs for themselves. So and I understand the problems, lawyers can be expensive. I can certainly understand that. And if either you can't afford an attorney or whatever, at least do some research on your case so you can get as informed as you possibly can about your case. I'm sorry.
In terms of your point about complexity, I was just about ready to write my document that I've been asked to do on dedicated funds.
Yeah.
And then somebody gave me the transcript of the February initial hearing on the Roman Catholic Bishop of Manchester versus the person who in the will gave the house, provided it always be used as the bishop's residence. And I discovered cypre wasn't always as simple as it seems to be.
Yeah.
And I said, holy mackerel, this is going really deep. Now, I'm not sure that's going to affect my ultimate document, but it just goes to prove the point. Once you think you've learned it all, don't think that.
Yeah, yeah. And so I guess what I'm trying to say here is that if that's the perception, so was the perception based on the judge ruled this way and you didn't prevail for some particular reason? You know, is that what you're upset about? Or would you be as upset about family division if you had completely won? Okay, if the judge ruled completely in your favor, would you be upset about the fact that there weren't rules of evidence?
There is a former state representative who actually won his case, who's still angry
Yeah, well, okay.
because this and that didn't happen.
Okay,
And should have,
well, yeah, okay.
even though I won.
Yeah, okay. Well, it's possible, sure.
It is possible, but highly. It is possible, but highly unlikely. The people that we hear from are people who, regardless of what the ruling of the court was, they believe that the ruling was incorrect, whether
One-
they want or not.
One aspect possibly that could be in this introductory booklet is if you feel that you, and I use the word feel, I usually use the word believe, but this is a motive, not rational, so I will use feel. If you feel that the judge made a mistake, was prejudiced, blah, 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 there are two things you can do. Number one, if you're going to appeal the verdict, it's not simply on the grounds that you lost. There has to be reasons to appeal. Here they are. And then secondly, if you believe the judge made discretionary rulings out of prejudice, here is where a complaint can be filed. And I think in the special committee, we said that how this could happen is if a particular judge is complained against in an inordinate amount of times, a judge from out of state or a judge who is retired could look through cases with the presumption initially that this is inadvertent. Let's say her honor was, in her honor's opinion, treated badly in her divorce 25 years ago and isn't intentionally against men, but might be subconsciously against. How do you know what you don't know is going on? And therefore, this is continuing education. You got to watch this. So to state, here's what you do if you lost and you're upset, because don't come to our committee to testify for us to redo your case.
Yeah. The other things that I typically see by way of support on that, Mr. Chairman, is that when you're filing an appeal, since family division courts have broad equity powers, and as the New Hampshire Supreme Court has routinely stated, basically we might have come to a different conclusion, but as long as there's an objective basis for the court's ruling below, we're not going to set it aside. So there's really only, for the most part, only really two ways you can appeal. Under Rule 7, if it's appealing from the merits of a trial, and it's not a discretionary appeal and it's a mandatory appeal, it's either going to be error of law. You could possibly attack a statute as being unconstitutional, but you have a real hard, that's an
Or the
uphill
judge
battle.
misapplied a
Right, yeah,
statute.
yeah, that would be error of law.
Error of law.
Okay, or you're going to have to show an unsustainable exercise of discretion to the prejudice of your case.
And that's the point I was just speaking to.
Yeah.
And that's it.
Yeah, and that's really it. And then the unsustainable exercise of discretion is what I like to call it, is the oh my God standard. Nobody on the facts as they were presented in this court below could possibly have come to this conclusion. And that goes back to the objective basis for the court's opinion.
Yeah.
So, and remember, and a lot of people also make the mistake of thinking that, she lied, the court never should have believed him. Well, witness credibility is an assessment that a judge makes. And typically, I'll be brief. Typically, you can believe a witness in their testimony entirely. You can believe all of it, some of it, or none of it.
But perjuries are difficult.
Yeah,
tasks.
perjury is difficult.
All right, I think we're done. Yes, we're not quite done.
So, Mr. Chair, to that note that Representative Markell was talking about, I wanted to ask Representative Markell,
Sure.
in cases in the family court, what is the appeal process, or is there a specific appeal process, or do you just have to file a motion?
Yeah, typically the process is that you get, if you want to get post-judgment relief, typically within 10 days of the court's notice of decision, you file a motion for reconsideration. And that's filed chapter and verse, I think it's Rule 135A off the top of my head. Let me double check it. I use it every now and then. Wait a minute. All right, well, at any rate, motions for reconsideration typically are where you basically it's sort of a mini appeal. What you do is you point out facts of law, facts misapprehended, or points of law, and you do it with specificity. Facts misapprehended, or a law that was applied erroneously. And then you're allowed to make pretty much any argument that you want to make. And typically they're limited to 10 pages, and you have to get it in generally within 10 days of the notice of decision. No response is required from the opposing party unless the court wants one, and then the court will rule on it. And then if your motion for reconsideration is denied, then you, as a general matter, have about 30 days from the notice of denial to file your appeal with the New Hampshire Supreme Court. And if it's a rule, and then depending on the nature of the proceedings below, it can be a mandatory appeal where they must review it, or it can be a discretionary appeal where they don't have to review it but can accept the case at their discretion. And that's typically how it works.
Thank you, that was my understanding.
Representative Nelson.
Thank you, Mr. Chairman. Just quickly, Representative Markell brought up a good point, and to my point that I'm always making about consistent assignment of the same judge to one case. I find with most people who come to me with problems, it's because there's been a change of judge, and the tone of the case changes, and it just struck a chord with me because you were talking about, like credible information from people. I think in the case of divorce, there's always, or sometimes, depending on who it is, somebody who's a charmer, right? So, this new judge might think, well, I disagree with this former, the former judge who was on the case, because this lady or guy doesn't seems okay, right? Seems nice, and maybe the other person's crazy. So I just think that, with the consistency of the same person throughout the, whole case, they can see through things,
This has been asked for in every look at committee for 30 years. One
Wow.
case, one judge.
Yes, I mean, even back to what you shared with us here, that was one of the biggies, and that was 94, I think.
Well, typically, to answer that question, typically, a judge will review the file. If it's a judge who's new to the case, typically a judge will review the case, and there may be notes in the file as well that the judge makes. And so they usually have a pretty good idea, and you can tell if a judge, and it's rare, but it unfortunately happens where a judge takes the bench and hasn't even read the file. Sometimes that's disturbingly obvious, but typically it's not the case.
I get this in one of my day jobs, where if one of my family practice people cannot continue with that patient on this issue, and another one does, they read the notes, but
Yeah.
occasionally one doesn't.
Yeah. And so generally they read the file, and then, you have to read it. Now, for example, to show you, one of the goals of any litigant is to try to prejudice the judge against one of the parties. That's typically the goal of one, you know, the other side is so-and-so and so-and-so. However, there's actually case law that I like to use, and I put it in, is that judges are supposed to go beyond the representations, okay, and supposed to look at the motives and look at everything else and just not take things at face value. And so I typically will put that case in as a reference in whatever it is I'm doing where it's necessary. And so those are things to think about.
I'd like to close our committee. Thank you all. I'm going to ask, I didn't actually realize I was doing it until I was doing it. I was also acting as my own clerk. I haven't been a clerk since my second year in the House, but still have the juices. And the last three items we discussed, I'm going to ask my committee assistant to email it to Representatives Rice, Gregg, and Raymond, who couldn't be here. And I'm going to ask all of us to keep reviewing the things, look at them, and Madam Chair, at your discretion, we may pick this up after the first of the year.
Thank you, Mr. Chairman. I agree, and again, I think it's imperative that we review the legislation that comes before us. We will start getting that legislation sometime after January 7th.
But we can at least see the titles, and if the titles look juicy, we can find the prime sponsor and ask for the LSR.
Correct, and then we can go from there as to really getting this task completed sooner rather than later. As you said, there have been many, many, many years, probably more than 30, that we could go back and look at, that families have been left in the lurches when they act in a pro se way. So we really have to do that. We really have to review the legislation and see. I'm not a fan of non-germane amendments, to be quite honest with you. But if we have to do it, we have to do it. However, I believe that much of what's coming down the pipeline is going to give us the opportunity to have a germane amendment and add some of this verbiage in. So I really want to work hard to do that.
Good, thank you. And we are adjourned.
Thank you.
Thank you.